Welcome to U.S. Immigration TV. Well, the Trump administration recently sent out an email that I think is very alarming and disturbing, especially to anybody filing a petition or an application for an immigration benefit, especially if they are out of status. In that email, the USCIS advises that if it denies a case, they may immediately issue a notice to appear, or NTA, placing the person in deportation or removal proceedings. And that is a radical departure from past practices under Biden, where USCIS may deny a case, but they would usually not put the person in deportation unless, let's say, they were an enforcement priority. Now, that email entitled, and I quote, USCIS initiates removal proceedings against 26,000 aliens since February, informs the public that since February 2025, USCIS, and I quote, has initiated removal or deportation proceedings against more than 26,700 aliens with no legal basis to remain in the country. Well, this is part of the Trump administration's efforts to, and I quote, to restore integrity and ensure the security of our nation's immigration systems. In particular, USCIS returned to a robust screening and vetting of immigration petitions and applications, which have led to approximately 1,840 NTAs a week being issued. And this email further notes that under the new guidance, USCIS is generally defaulting towards issuing NTAs after the issuance of an unfavorable decision, meaning a denial, on a benefit request where the alien is removable from the United States. In only limited circumstances will the USCIS exercise prosecutorial discretion, meaning only in limited situations will they not issue an NTA upon a denial. Now, what does this mean? This means that if a person files a petition, whether it is a family-based petition, an employment-based petition, or an application such as, let's say, adjustment of status or a fraud waiver, and that petition or application is denied, well, what could happen then is USCIS may then issue an NTA placing that person in deportation or removal proceedings if that person has no authorization to remain in the United States, as they say in that email. And a case can be really denied for so many insignificant little reasons. For example, you check the wrong box on the form. Not all the required evidence proving eligibility was submitted, because USCIS has a website, and when you file a petition or application, they list the required documentation. If you happen to miss one of those documents, are they going to deny it and then put you in deportation? Or sometimes the USCIS believes that not enough evidence was submitted proving eligibility. Let's say a marriage case, you didn't submit enough pictures or enough letters to each other. Or there could be a miscommunication or misunderstanding, let's say because the case was not properly packaged or presented. Now, in the past, USCIS may have issued a denial, but the person may have had the opportunity to bring a motion to reopen or reconsider, or even refile the case and repackage the petition or application. Or USCIS would just generally deny the case and then leave them alone. But with this email, with this warning, the Trump administration is saying that that policy will no longer be the case. And that if a case or a denial is issued, the person could be placed in deportation or removal proceedings. And in such a situation, this is what I recommend. If you're going to be filing anything, a petition or an application, I would highly recommend that you first consult with an attorney in connection with the preparation and filing of your petition or application. Now, I know what many people think, that they want to do the paperwork on their own. They want to file it on their own because, of course, you can save attorney fees. And if they get a denial, that's when they're going to go see an attorney to help them out or try to fix it. But now with this policy of Trump, where it's deny and deport, the stakes are so much higher because ordinarily upon a denial of a case, the person would be considered out of status or tago ng tago because it was that petition or application that was keeping them in status and in the US. But upon a denial, they're out of status and therefore they are a target of removal or deportation. Now remember, Trump originally said he was going to focus on enforcement priorities, which is the terrorists, the felons, the gang members. But now they are considering people who violate their immigration status or are out of status or who entered the US illegally. They're saying that they broke the law because there's, of course, immigration laws about going out of status. So the logic is somebody going out of status is violating the law, and that makes them just as subject to removal as a terrorist or a felon. And he wants to report all these glorious numbers of people he's been putting in deportation. I mean, that was the whole purpose of that email, to say, look how many people I am deporting. And you are just as deportable if you're out of status as a result of a denied case as being a felon. That's why I'm not trying to scare you. I'm trying to warn you or advise you that because it's getting so risky in terms of filing immigration and a denial could result in deportation, you may want to see an attorney. I hope you found this video informative. It is the purpose of this channel to keep posting news and advice or tips and developments in immigration law. And believe me, under Trump, immigration law is practically developing on a daily basis, but not for the better. It just is getting more tough. And I know that people are now, even green card holders, afraid to go out of their houses, afraid to leave the country. And that's why, if you want to be kept updated on the latest news and developments, make sure to like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.